How does retirement division work in Massachusetts divorce? Hi, I'm Bill Farias, founder and CEO of Farias Family Law. We are a divorce and custody firm in Southern Massachusetts. And this question comes up very often because you have a lot of people who are getting divorced who have retirement saved up. And some of these people are afraid to lose a big chunk of their retirement. Some are excited to be gaining some retirement savings for this next chapter of life. And this is to explain how this all works in the context of divorce. First of all, it's important to remember that in Massachusetts, everything owned by either party, whether individually or jointly, is subject to division. In other words, it may be divided. So doesn't matter whose name is on the account, doesn't matter when you accrue the retirement, it's technically in the pot for division. Now, the second point is really important, which is whether it is actually divided and how much is transferred depends on the individual facts and circumstances of your particular case. There are a number of factors that a judge considers in determining whether to divide a retirement account, how to divide it. And so you're looking at length of the marriage, contributions to the marriage from the parties, age, income, other assets, potential to acquire assets in the future, and many other factors. The bottom line here is that the factor that has the biggest impact is the length of the marriage. What we found is if you have a very, very short-term marriage, let's say someone's been married or a couple's been married for about a year, they are calling it quits. Usually a judge is going to have those people go their separate ways with what they have, and they will not delve into retirement division. The longer the marriage, the more likely it is that the retirement accounts are going to be divided. Next, in determining how much exactly is going to be transferred and what that division looks like, it's also important to recognize that most judges will stick to the marital portion that's been accrued. So although all of the retirement is in the marital pot, most judges will divide what's called the marital coverture period. So all of the money, the retirement money that was accrued during the marriage, the gains in value during the marriage, that's usually divided in divorce, especially in all but short-term marriages. Finally, in terms of the actual division, you have to figure out whether you need a qualified domestic relations order. We call those QDROs, QDRO. And a QDRO is simply a document that instructs the plan administrator on how to divide a retirement account and gives permission to divide the retirement account consistent with what's in the agreement or the court order. So QDROs are necessary to divide generally pensions and some direct contribution accounts like 401ks and 403bs. You generally do not need a QDRO to divide IRAs. Usually with IRAs, you're filling out some paperwork and you can get that split pretty quickly. With QDROs, you got to have this document drafted. We have some providers that we recommend when clients need this done. We are not QDRO experts, so we will connect you with a qualified professional who can do that for you. So in terms of how they're divided, if it's an IRA, you probably don't need a QDRO. If it is a 401k, 403b pension, you probably do need one. Talk to an attorney if you have any questions about this. You can call us 508-675-0464. You can email us at info@fariasfamilylaw.com. If you found this video helpful, please share it with anyone you think might benefit from it. And you can find us on social at Farias Family Law. Thank you. Have a good day.